Hi everyone, and welcome to week 3 of Common Law 2. I want to pick up where we left off. We are talking about substantive due process, and specifically about those rights that the Supreme Court has already said are fundamental rights. So these are rights that you don't have to worry about whether they should be fundamental. They are. Just to remind you how that works, your mental checklist, when you're looking at a fact pattern where there seems to be an unenumerated right involved, you sort of want to first ask yourself, has the court already dealt with that right? And if it has, just go to the appropriate level of scrutiny. Or conversely, is it something the Supreme Court has not tackled before, in which case you'd have to do a full analysis. Put another way, if the Supreme Court hasn't already said that it is, so you'd ask, is it a fundamental right already? And if the answer to that is no, the next question you would ask would be, should it be a fundamental right? That's when you apply your two factors to do that analysis. But we've been making a list of rights the court has already dealt with, and so far we know that marriage, marital privacy, procreation, the right to refuse unwanted medical treatment, that those rights have gone on the list. We know conclusively that economic rights at this point in our history are low-level rights that get Lee optical rational basis review. We also know that physician-assisted suicide, or suicide in any form, is not a constitutionally protected liberty interest, or otherwise known as a fundamental right. So in this video, let's quickly add some more and keep this moving. We're going to talk in this video, and there's going to have to be a few videos here coming before we set up the abortion issue. Because first I want to talk about family living generally and some family issues here. After that, I'm going to do a separate video on Michael H. because that deserves its own short video. And then after that, I'm going to do the stuff in here about it deals with sexual orientation, but in the context of rights rather than classifications. Of course, that issue's been dealt with under both the due process and equal protection. But we'll talk about the due process cases around that issue, LGBTQ issues, because that too kind of is its own area of law. Specifically, I should say that it's not its own area of law, but it's been dealt with in a certain way by the Supreme Court, particularly when Justice Kennedy was leading the way. So that kind of requires its own explanation. Let's start our discussion of this family living and family rights with Belter versus Boras, a case from 1974. This was a case in which a municipality said, only so many unrelated persons can cohabitate in one place. The obvious import of the law, the obvious goal of the law, was to stop fraternities and sororities from having houses in a certain neighborhood. And there was a lawsuit claiming that this violated the fundamental right to decide who you cohabitate with. So you would start. First of all, it's a subdivision of a state, right? So deciding who you live with is not mentioned in the Constitution. Up to this point, it was never a right that the Supreme Court had dealt with. So in terms of the text, you would cite the 9th Amendment, the 10th Amendment, right, and the 14th Amendment, because it got into subdivision of the state. Then you would move on to the question whether it should be a fundamental right, because the Supreme Court has never said it was. And you know how that works. You get to the question, living arrangements, right, of unrelated persons. The court frames it that way, the right of unrelated persons to cohabitate. Is that deeply rooted in our nation's history and traditions? Arguably, the court says not, because throughout our history, most of the time the honored practice in our tradition would be for families to cohabitate, the family unit. Keep that term in mind, right? The family unit. So the court says there is no deeply rooted tradition in the United States of unrelated persons cohabitating. Furthermore, if you look at the second factor about whether a right should be fundamental, the court says this is not implicit in the concept of ordered liberty. The question here is, would society fall apart if the frat house couldn't dwell next door? And the court's not going to go there. The court doesn't see anything. This is not one of the building blocks, right, of a free society. Zoning ordinances like this are pretty common. You know, it's not like if you live in a place with zoning ordinances about what types of housing units can go where, that you're not living in a free country. So the court is unpersuaded. Now, don't forget, when you find that that a right is low level instead of fundamental, you're not done yet. Keep this in mind, right? Now you have to apply rational basis review. In this case, then the challengers would have the burden of persuasion to show either that there's no legitimate interest or that the means are not rationally related. Here, there's going to be no problem, right? This doesn't involve saving lives or saving the children or anything, but the point is it doesn't have to, because the Supreme Court is not applying strict scrutiny, it's applying rational basis review. So all we're looking for here is a legitimate interest, and it's up for the challengers to prove that there isn't one. It's pretty easy to find that there is one, right? To stop, I mean, I was president of a fraternity in my college, so I'm not anti-fraternity, but so I can say this. You know, if you put a fraternity house next to my residential residence, you might as well put a prison there, right? In terms of what it's going to do to my property values and maybe even worse than that, right? My property value and quality of my life and enjoyment of my property. So there's no question that there's a legitimate interest in preserving property values and the peaceful enjoyment of the neighborhood. Then the only remaining question is whether this is a rational way to do that, and it is. Stop a fraternity house or sorority house or some similar types of arrangement from moving in next door is a rational way to achieve the interest. So the court says, so remember this, because we're building a list of rights that are fundamental. You could also list some that aren't, like I just said. Economic rights are not. Suicide is not. Physician-assisted suicide is not. And now we find out that the right of unrelated persons, right, to cohabitate is not, and is not a fundamental interest. Now contrast that with Moore versus East Cleveland, which is a case that is often cited in substantive due process cases, especially lately, for reasons maybe we can talk about later. This involves a grandmother who's not allowed, under a zoning ordinance again, is not allowed to live with her grandchildren. I mentioned this in a previous video, I think. Who's not allowed to live with her grandchildren because they are cousins instead of siblings. So now the right isn't the right of unrelated persons, right? There's all these rules about consanguinity, right? I think I got that word right. I'll check with one of the Wills professors to make sure. But degrees of consanguinity that people have to cohabitate, right? These are all these complicated rules. And it turns out that under the local ordinance, grandma can't live with her two grandkids because they're cousins, they're not siblings. So in other words, she's taking care of two of her grandkids, but each one of her grandkids is the child of a different one of her children. Now, the question isn't the right of, as I was saying, is not the right of unrelated persons to cohabitate, but the right of related persons, right? So now we're going to call this family living arrangements. Family living arrangements. And think about the big picture. Is that your business? Who, right, in your family you live with? Or is that the government's business? That's what these fundamental rights, substantive due process, liberty interests are all about. Now here, again, up until the point where Moore was decided, the court had not decided whether family living arrangements were a fundamental liberty interest protected by the Constitution. So this is the first time they're going to tackle this. So what do we got text-wise? Once again, it's subdivision of a state. You have the 9th, you have the 10th, you have the 14th. Then you ask the question, has the court dealt with this yet? As of then, the answer is no. The court had not dealt with it yet. Okay, so should it be a fundamental right? And then you apply your two factors. Is it deeply rooted in our history and traditions, right, of the United States? And is it implicit in the concept of ordered liberty? Now, typically, if you're an originalist, the farther back you go, the less likely it's going to be that whatever you're talking about was a fundamental right or was considered a fundamental right at the time, 1791 or 1868, right? Most of the time, again, the further back you go, the more restraint, particularly as to people's privacy and their own lives. The more restrained this whole deal, the more narrow this whole idea of liberty was, right? The roles that of women, the roles of all kinds of different groups of people. Obviously, ethnic minorities, right? LGBTQ, as I mentioned, right? These things were different in if I need to say it, right? I mean, different in 1868, 1791 than they are now. And typically, if you go back that far, you're an originalist and you anchor yourself to 1868, You ask about something like sexual liberty or contraception or abortion for certain, you're going to find out that the answer is no, that was not regarded as a fundamental right in 1868. So, this is one of those rare instances where the more originalist you are, the farther back you go in our country's history, the more likely it is that you actually find that it is a fundamental right. That's kind of a weird thing about this case. Why is that? Well, because as the country has evolved into modern times, now it's very common for families to be widely dispersed, right, and split up and all live in different states and regions, never mind, right, different households. But the further back you go in our history, the more likely it was you were going to find in one household, right, lots of family members of different degrees of consanguinity, where you have aunts and uncles living under the same roof, you have multiple generations living under the same roof. So again, the further back you go, the more likely you were to find that. So the court here has no problem saying that this is, in fact, deeply rooted in our nation's history and traditions, that people and families get to make the decisions about whom in their family they're going to live with. Now let's talk implicit in the concept of ordered liberty. Family living, is that something where, look, if the government can tell you you're not allowed to live with your grandkids because they're cousins, if that's the kind of decision that the government can make for you, instead of leaving it up to you to decide whether you want to live with two grandchildren who are cousins, do we really live in a free society? And I might certainly ask, family living arrangements, is that foundational? Never mind to a free society, is that just foundational to our society, period? Is it part of the fabric of our society? If you pull this string out, right, does the whole thing start coming apart? And the court clearly is sympathetic to that idea as well. That, in a free country and in a society that's built on the family, that this right is implicit in the concept of ordered liberty. As always, don't stop there. Remember, once you arrive at whether it is a fundamental right or not a fundamental right, and put this on your list, right? The family living arrangements are a fundamental right. Once you've done that, you have to apply strict scrutiny. Under strict scrutiny, you look whether the means are narrowly tailored to a compelling interest, and what in the world is the government going to argue in this case? What are they going to say? Save the children? In a case where they're stopping grandchildren from living with their grandmother? If you're going to say save the children, which is of course the ultimate claim of compelling state interest, you're going to have a real problem here, because stopping two kids, what are the alternatives here? Either these kids are going to live with grandma, who's going to take care of them, or they're going to become wards of the state, or at least one of them is going to become a ward of the state. Those are your two alternatives. So you can't say that you're trying to achieve a compelling interest. This is to preserve the family, this is to help children. Nonsense. The means not only are not narrowly tailored to achieving that interest, they actually achieve the opposite. So, this is a no-go. This is a non-starter. The Supreme Court says, nope, it is not up to the government to decide which family members live with which other family members. So, what do we find out here? Because I think this video has probably run long enough, so we haven't got to other family stuff yet. But what do we find out here, just from these two cases? The right of unrelated persons to cohabitate, not a fundamental right. Family living arrangements, cohabitation, that is a fundamental right. Put it on your list of fundamental rights, fill it in on your grid, and apply strict scrutiny whenever you see it. And until the next video, stay safe and stay tuned.